Hi again, everyone. This is Mark Movsesian. I'm the director of the Center for Law and Religion. I'm joined by my friend and my colleague, Mark DiGirolamo, the Center's associate director, for another episode of Legal Spirits. This is our podcast series on issues and cases in law and religion. You can listen to archived podcasts at our website, lawandreligionforum.org, that's one word, and also on iTunes. Well, today, Mark, we want to return to a topic we've talked about in a couple of other podcasts, and that is the Bladensburg Cross case. Last week, the Supreme Court handed down its opinion in the case, and it was a case that we had predicted the outcome in. I'm happy to say right at the start, we'll talk a little bit about that, but we turned out to have predicted things pretty well. And it's a case that may have broader implications or narrower implications. And in this podcast, Mark and I are going to address the court opinion and also discuss the implications. And we have some slight disagreement about what the implications would be. Okay, Mark, so why don't you remind our listeners about the facts of the case?
Okay, so we've now talked about this, as you say, a few times, and I certainly won't get into the detail that I have in the past, but just to remind readers, this is the case concerning the 32 to 38 foot cross that sits in Prince George's County and sits on an island which straddles a highway. It's a cross that has been there since it was dedicated in 1919 and erected in the mid-1920s, and it's a cross that was intended by the residents of Prince George's County to honor the fallen soldiers of the county, fallen soldiers in World War I. So that's the cross itself. In the mid-1960s, ownership of the cross passed to the county. It was funded initially with private donations and monies from the American Legion and others, but title to the cross passed to the county in the 1960s, whereupon the county began to pay for the upkeep of the cross and reparations to the cross since, really fairly small contributions by the public for the upkeep and safety of the cross. Since it's over the highway, you got to make sure it doesn't collapse onto the highway, these kinds of things. But that's the situation, and the American Humanist Society in 2012 sued, claiming that the cross is a violation of the Establishment Clause. So the court picked up this case. It's the first case.
Well, we should say, Mark, and the Fourth Circuit said that was right.
That's right. I neglected to say about the Fourth Circuit. I believe actually the district court upheld the cross, and then that was reversed by the Fourth Circuit in a 2-1 panel decision, with the Fourth Circuit saying that the cross is a violation of the Establishment Clause, proposing various solutions like lopping off the arms of the cross to remedy what was felt to be an Establishment Clause problem. So at that point, the Supreme Court picked the case up, and they don't do this very often with this kind of category of case. The last pure religious display Establishment Clause case, I think you have to go all the way back to 2005.
Yep. Ten Commandments cases.
So that's, whatever it is, almost, 15 years since we've seen a pure case like this, even though there have been other cases that have implicated similar issues.
Yeah. Okay, so it got before the court, and last week the court decided by a vote of 7-2 that the Bladensburg Cross is constitutional. That is, it doesn't violate the Establishment Clause. But the lopsided vote, which I want to say again, Mark and I predicted this, and listeners can go back and listen to our podcast from March, in which we kind of predicted how the court was going to come out. We said that it was going to be a 7-2 vote. Actually, both of us went on the record with that. We said there was likely to be a number of different opinions. We kind of predicted Gorsuch would go his own way, and so anyway, we're sort of proud about
we're crowing about this.
We're crowing. We're sort of proud how we did in this case. It's maybe one of the rare opportunities we'll have, so we need to make the most of it. Anyway, so the court decided by 7-2 that the cross was constitutional. Justice Alito wrote the majority opinion for himself and for Chief Justice Roberts, and then Justices Breyer, Kagan, and Kavanaugh. And he said that longstanding religious displays like this one have a presumption of constitutionality, a presumption that is informed by history and tradition. So the Latin cross, the Bladensburg cross, was, as Mark says, was a big Latin cross, obviously has a Christian meaning, but he said it also had another meaning, an additional secular meaning, because during World War I, it acquired a meaning as a commemoration of servicemen who had died in the conflict. These Latin crosses were very familiar to people at the time from the war cemeteries over in Europe. By the way, I was also proud, Mark, that Justice Alito quoted the poem In Flanders Fields, which I actually quoted in our podcast too. So we're just great listeners. You should always pay attention to what we tell you. Okay, that's a joke. So number one, it had this additional meaning, not just a Christian meaning, but also an additional meaning. And it was very hard to disentangle those, Justice Alito said, particularly 90 years later. Second, Justice Alito said that the passage of time had given the Bladensburg cross new meaning. And so for many, he said, the cross now symbolized the local community itself. The men who had died in the war, their relatives, friends, and neighbors who had erected the monument, and, crucially, the descendants of both of those groups who had maintained the cross ever since. There was no evidence that the county had been trying to disrespect non-Christians who had died in the war, or that they had done anything since to disrespect non-Christian county residents. This had become, over time, a representation of the entire community. That was another meaning that the cross had. And finally, Justice Alito said that many people would see removing the cross now or defacing the cross, and Mark, you correctly say the appeals court had suggested maybe we could just cut the arms off the cross and make it just a big post. That would solve things. So defacing the cross now would actually be seen by many people as an insult to religion, not a reflection of neutrality. And so he said, I'm quoting now, "A government that roams the land, tearing down monuments with religious symbolism and scrubbing away any reference to the divine will strike many as aggressively hostile to religion." And that would not be consistent with the goal of the Establishment Clause, which was, quote, "a society in which people of all beliefs can live together harmoniously." So that's the majority opinion.
Okay, yeah, so that's the majority opinion. And would you say, Mark, and I think this phrase comes up several times in the part of Alito's opinion that constitutes the majority, that the court now has a jurisprudence of, quoting the court here, old monuments, symbols, and practices.
Yes, I think that's the way to look at it, Mark. I think certainly now when it comes to old, as you say, monuments, symbols, and practices.
Because that is a phrase that you can see over and over again.
Over and over again. They are presumptively constitutional. It actually looks like a strong presumption of constitutionality. And that's for sure what the opinion says. And that itself is kind of a victory for people who think there should be religious displays allowed in the public square, because there are a lot of long-standing monuments and their constitutional status was not entirely clear up till now.
Monuments, symbols, and practices, yes. which is actually... So we're not talking, it seems to me, even if we take the majority opinion, we'll get into exactly how narrow it is and so on, but just taking the majority opinion on its own terms, it sounds like we're not dealing just with the cross itself or with the Ten Commandments monument itself. We're dealing with any monuments, symbols, and practices that are old.
Okay, here, Mark, we get into one of the disagreements that we have about this case, because it is true, you're right, the phrase that Justice Alito uses in his majority opinion is monuments, symbols, and practices. However, the case...
Multiple times.
Yeah, multiple times, listeners, multiple times. However, the case is about a monument. And symbols and practices, I could see some people saying, well, that's just kind of dicta, because that's not what this case was really about. But I will agree with you. He says it many times, and that is that's something to think about for lower courts. That's what it extends to.
Okay, well, so at the very least, what we have is a jurisprudence of old monuments.
Correct. Now, the question is whether it would extend also to new monuments, that is to say, new crosses that a legislature might vote to put up in a town square or something like that.
Okay, well, so before we even get to that issue, new monuments, there was a majority opinion, but there was also a plurality opinion, which included part of Justice Alito's opinion. So you want to talk a little bit about that, Mark?
Well, so Justice Alito's plurality opinion had a long discussion, and this was written for himself, Chief Justice Roberts, Justice Kavanaugh, and Justice Breyer. So he lost Justice Kagan on this. He has a long discussion of why the Lemon endorsement test doesn't work in this context.
Right, and the Lemon endorsement test, just as a reminder for our readers, concerns this test from 1971, Lemon versus Kurtzman, which it has been used by the court in various Establishment Clause contexts. It's got three components. The court is supposed to look to whether there is a secular purpose for, in this case, the religious display, whether its primary effect is to endorse religion or support religion, and number three, whether the monument suggests excessive entanglement between the government and religion.
Right, and the key factor under Lemon in most of these cases is whether a reasonable observer would understand the state to be endorsing religion by putting up these monuments.
Yeah, it's sort of an interpretation of that second element, that is to say, whether the primary effect is one of endorsement in the mind of a reasonable observer.
Right, and conservatives have criticized this case for decades now. They say it's manipulable. It is also inconsistent with many traditions in America that go back for centuries, like the national motto, "In God We Trust," and so on. And Justice Alito's plurality kind of took that view, that the Lemon test, certainly in the context of symbols and monuments and practices, simply doesn't work, is manipulable, and should be gotten rid of. But that's a plurality opinion. And Justice Kagan specifically did not join that section of the opinion, and indeed wrote a concurrence in which she said, "I think the majority opinion is consistent with Lemon, and I think Lemon remains crucial." So we'll talk a little bit later about what to make of all of this, but it's important to know that there's no majority opinion in this case overruling Lemon expressly. And then there was another section of Justice Alito's opinion which dealt with whether history and tradition could be a test in this area. He harkens back to an earlier case involving legislative prayer, the Town of Greece case, and talks about how history and tradition are so important in informing questions of constitutionality of symbols and practices and monuments. But again, Justice Kagan didn't join this part of the opinion
Justice
either.
Kagan says, out of an excess of caution, I don't join that part of the opinion, even though I find much to admire in that part of the opinion.
Okay, so here's another debate Mark and I will have. Okay, now, there are other separate opinions in this case, Mark, and a particularly interesting one was a concurrence in the judgment by Justice Gorsuch, joined by Justice Thomas.
Yes, so I want to talk about that, but first I want to just say something about Justice Thomas's separate concurrence in the judgment. So I'll talk about both of those. Justice Thomas's concurrence in the judgment, just for himself, emphasized really 2 points. Number one, he came back, and I think we predicted this as well in our earlier podcast, he came back to a theme that he has been hammering for a long time now with respect to the Establishment Clause, and that is that the Establishment Clause should be read as simply a jurisdictional feature preventing the federal government from interfering with state decisions concerning the relationship of church and state. So that's the view that he has had for a long time. There is historical support for that view, but so far Justice Thomas has not been able to convince any one of his colleagues to join that position. Now, there's a second part of Justice Thomas's concurrence in the judgment that I want to emphasize, and that is with respect to what the test ought to be or larger concerns about Lemon, Justice Thomas says specifically in Part 3 of his opinion that he finds Part 2A of Justice Alito's opinion, which Mark just talked about as the plurality part of the opinion discussing Lemon, to be convincing. And he explicitly says that he agrees with that part of the opinion. And he cites to Part 2A in saying that. So what makes this a little bit unnerving is that Justice Thomas also, of course, doesn't officially join that part of the opinion, because if he had, that would have been a majority opinion. However, it's interesting to think about what actually constitutes a holding. Namely, sure, he didn't actually join Part 2A, and yet he says in his opinion that he explicitly agrees with Part 2A and cites to Part 2A. So always, I think, when law professors or anybody else are thinking about what the holding of a case is and what its dicta is, there are kind of fuzzy areas where one isn't sure exactly what constitutes the holding of a case.
Yeah, so, and I would just respond to that by saying that, and by the way, I should be candid with listeners, I'm not a fan of the endorsement test. I'm not saying what I'm saying because I want the endorsement test to stay. But, the fact is, even though Justice Thomas did say those things, indicating his agreement with what Justice Alito was saying in the plurality part of the opinion, he didn't join. He is concurring in the judgment. He specifically did not join. If he had joined, as you say, there would have been a majority opinion. And let me just say, when it comes to lower courts, if here Mark and I are debating, and in all good faith, because it's complicated, if we are debating what the holding of this case is, that's a problem, because it doesn't really give much guidance at all to lower courts. And I think it's fair to criticize the court for this.
I agree with that. We're engaging in all of this back and forth because, frankly, it's a very difficult opinion to disentangle. And I think lower courts, I agree with you, I think lower courts will find it so.
Which also, by the way, gives lots of room for lawyers to argue the endorsement test still stays there.
Sure, and for a different test.
Right.
To say that a different test applies in light of what Justice Thomas did in this case. Justice Gorsuch.
Yes, let's talk about Gorsuch.
Yeah, so Justice Gorsuch had a concurrence in the judgment. He also had lots of extremely critical things to say about Lemon. I think it's fair to say both Justice Thomas and Justice Gorsuch are interested in overruling Lemon completely for all issues, and they made that plain in their concurrences. Justice Gorsuch started with a discussion of what he called offended observer status for standing purposes. And I think his preferred approach would have been to get rid of all of these kinds of cases on standing doctrine grounds. And again, I'm going to crow a little bit. We did say in our earlier podcast that at least one or two justices might go in this direction. It turns out Justice Gorsuch was the one to find this avenue appealing. In the second part of his concurrence in the judgment, or the latter part of the concurrence in the judgment, Justice Gorsuch indicated his support for a history and tradition test, but only if that history and tradition test would include new monuments. He said, we're not just interested in whether a particular monument is old, but whether the monument, new or old, fits within the larger tradition of practice more broadly followed.
Yeah, and I have to say, if one is a traditionalist in these matters, as Mark is, and as I am too, in a way, that makes much more sense, because to say that a cross will survive only because it's old really is not tradition, it's antiquarianism. It just says something is old, it's okay. Whereas a traditional approach would say, well, the tradition continues to live, and if you continue to do things that are like what has been done before, that's tradition. Okay.
Now, I just want to add one thing, having written a little bit about this. There's always a debate when we talk about history and tradition about how broadly or narrowly to draw the tradition. So the fact that some justices would have drawn the tradition of practice here to include only old monuments, and some justices think that the tradition actually includes new monuments, is simply part and parcel of justices debating among themselves about exactly what the tradition is, how to draw it.
I guess. I mean, I might say no matter how you draw a tradition, if it's being defined coherently, has to include new things in the tradition.
I agree with that.
Okay, and just to finish up, we should say that there's also a dissent in this case written by Justice Ginsburg for herself and Justice Sotomayor, saying that the cross is unconstitutional. They would have stuck with the Lemon test.
And that all crosses are unconstitutional. I think that was a fairly broad dissent, actually.
Yes, right. Okay, so now let's talk about some of the implications of this holding for future cases. And one question is whether the opinion, which, as we say, applies to old monuments, that's not a problem, whether it also extends to new monuments. That is to say, what if a town were today to set up something like the Bladensburg Cross? Would that be constitutional? Well, that's unclear. I think you could read the majority opinion to say that a new cross would be constitutional. It's possible to read it that way. On the other hand, two of the justices who joined the opinion, Justice Breyer and Justice Kagan, wrote separately. Actually, it was Justice Breyer concurring along with Justice Kagan to say, actually, as far as they're concerned, that would be a very different case. So they went out of their way to say, we joined this opinion, but we do not think it necessarily means that newer crosses would be okay too. This just goes to older crosses that have been there for a long time and were not discriminatory. Now, as Mark said, we have concurrence in the judgment by Justice Gorsuch, joined by Justice Thomas, saying actually new crosses would be covered or new monuments would be covered. So I think, Mark, it's fair to say there really is an open question here.
I think that's right. You also, by the way, we haven't mentioned it yet, but there was a concurrence by Justice Kavanaugh.
Yes, I should say that there were, in addition to the majority opinion, there were 7 separate opinions in this case, which goes back to what we said before about what a mess this is for lower courts.
So Justice Kavanaugh's opinion, it seems to me, would favor a history and tradition approach, would be favorably inclined toward at least finding some new monuments to be constitutional. But I do think that there's perhaps a point of fracture between new monuments as such and new monuments where there is also evidence, perhaps a lot of evidence, that the monuments were erected for discriminatory purposes or to really stick it to one kind of religious constituency. And if you remember, Mark, in Town of Greece versus Galloway, there was a similar kind of argument about legislative prayer, right? That if you have legislative prayer that was intended to denigrate some kind of particular religious constituency, well, that's not going to be okay. That's not the kind of religious expression or monument or a similar kind of issue that is going to be within the tradition of practice here. So I agree with you. Bottom line, I agree with you. The status of new monuments is unclear. There are probably different positions within the court, even within the court's majority, plurality, and concurring justices on that question.
And, frankly, you say discriminatory, but I frankly would see Justice Kagan and probably Justice Breyer saying, actually, the endorsement test still applies in that circumstance. If you put something up today, we're not talking about something old. Justice Breyer says, I don't want to go around, fighting shadows. But if you put up something today, I would be surprised if Justice Kagan said, well, the feelings of a reasonable observer as to what the government means when it puts this up are not really relevant.
Maybe, although it should be pointed out, Justice Breyer joined Part 2A of the majority opinion, and that opinion, that part of the opinion fairly clearly rejects the Lemon test, and even Justice Breyer, in his concurring opinion, doesn't cite to Lemon.
Yes, although he does say this gets us to our next point. So one question is, what about new monuments? The next question is the one, well, what is the test going forward? What is the broader implication of this case? And Justice Breyer, in that same concurrence, says, I don't think we're announcing. I don't view this decision as announcing a new history and tradition test, even though, as you point out, he signs an opinion which talks a lot about history and tradition.
Correct, which is, again, baffling. You've got justices who say they agree with parts of opinions that they refuse to join, and justices who join parts of opinions that then they say that they reject. So it's very, very confusing.
Yeah, and as a former Supreme Court clerk, to me, it might be late in the term sloppiness, that they just have a lot to do at the end, and that may be why Justice Breyer writes this separately, just to make sure that people know he signed on to it but didn't mean that. Of course, Justice Kavanaugh says we do have a new history and tradition test here. He signed the same opinion.
And there are also features of Justice Kavanaugh's opinion and Justice Thomas's opinion, these concurrences in the judgment, that emphasize an additional possible feature of a new test, the coercion element. Both of those two justices seem to focus in on that. It would surprise me if Justice Gorsuch, I think he said something about coercion as well. But so some kind of coercion plus tradition and history test seems to be the sort of approach that at least 4 or 5 justices support.
Right, and so to wrap this discussion up, I think, Mark, you and I can state our disagreement, which is maybe a narrow disagreement, but still an important one. I look at this case and I say, well, this is a narrow victory for people who think that government should be allowed to erect monuments and engage in practices and just display symbols that have religious elements, because it says that long-standing monuments and symbols and practices are constitutional or come with a strong presumption of constitutionality. Presumption of constitutionality, I'm adding strong because I think when you look at it, it looks like a strong presumption. And that's it. I would say other than that, I really don't know what this court means about the future cases involving new displays and new monuments, and I don't think that they are meaning to suggest there's now a new test in this area. But I think, Mark, you may have some disagreement.
Okay, so I don't think that there are as many disagreements as may first appear. To the extent that there are disagreements of very slight shades of emphasis. So, number one, I agree that this is a comparatively narrow case. The court could have done much more. It could have gone much further. Number two, I agree that what we have now looks like a new jurisprudence of old monuments at the very least, and I would add monuments, symbols, and practices. It's a term that appears numerous times in the majority opinion. And number three, I'd say even that, it seems to me, is a considerable expansion or a considerable change from the existing Lemon endorsement test approach, which is to say you've got this presumption, this blanket of protection for old monuments. Old is not defined anywhere, so that's going to invite a new round of litigation about exactly how old is old enough to get the presumption. But that's already, it seems to me, a real change in the way that the court deals with some of these questions. I think litigants are ill-advised to bring any new cases concerning monuments of a certain age. And I would say once you've got 40 to 50 years plus, those cases are likely not going to go anywhere unless you have got very, very strong evidence of discriminatory motivation or something like that. And then the final thing that I'd say is I think that taking all of the various opinions, and there are a lot of them as you've mentioned, and putting them together, you can see at least where I would say a majority, if not a plurality, if not a majority of the court thinks, how it thinks about what the test ought to be. Agreed, though, this case did not establish what that test is, but I think that for lower courts and for litigants, it seems to me the writing is on the wall.
Okay, well, we'll leave it there, Mark. Thanks very much for listening. Once again, this has been another episode of Legal Spirits, which is our podcast series on issues and cases in law and religion. You can find past episodes at lawandreligionforum, that's one word, .org, and also on iTunes. Until next time, this is Mark Movsesian with Mark DiGirolami from the Center for Law and Religion at St. John's University.